Good morning, everybody. My name is Adam Weller. I am the Assistant Commissioner with the Office of Labor Standards. Also on the webinar is Richard Ruff. He's one of our supervisors here. He'll be answering questions live in the Q&A section. So if you have any questions during the presentation, feel free to ask them. He'll be answering them live. Otherwise, if we can't get to them during the presentation, you'll have an opportunity to have them answered at the end of our webinar. So for today, we're going to just do an overview of Chicago's Fair Workweek Ordinance and also provide some additional educational resources that we have online and available at all times on our website. So for today's webinar, we'll give a little overview of who we are, what we do, which ordinances we enforce. Talk about what is the intent of the ordinance, what's its purpose, why does it exist? Then, of course, who's actually covered by the ordinance? A lot of our worker protection laws cover a majority of workers within Chicago. This one is not the case. It has specific criteria that must be met. So we'll talk about that, who's covered as an employee and also who's covered as an employer. What actually is the Fair Workweek Ordinance? What are the benefits it provides? How does it protect employees? What are the exceptions to the Fair Workweek Ordinance? Does it apply in all situations? No, it doesn't. So we'll talk about those. Mutual agreements. Mutual agreements are one of the exceptions. We get a lot of questions about that. We'll cover that topic as well. We'll speak about retaliation, retaliation from an employer on an employee who's exercising his or her rights under this chapter. We'll go over some frequently asked questions and also how to access the frequently asked question document that we have available in both English and Spanish on our website. And speaking of the website, we'll go over that as well too, so that you're aware of all of the resources that you can access at any time in many different languages, and also how to view past webinars on our YouTube channel. We'll provide you with our contact information that you can contact us via email, via phone, in case you have any further questions that weren't answered in the webinar, or if you have anything overly specific or legal that we can't answer publicly on this webinar. So who are we? We're the Office of Labor Standards. We are dedicated to promoting and enforcing Chicago's labor laws. What are those laws? Well, there's an anti-retaliation ordinance, domestic worker contract requirements, Fair Workweek Ordinance, which we're going to talk about today, of course, the Chicago Minimum Wage Ordinance, Paid Leave and Paid Sick and Safe Leave Act, which was updated recently in July, and the Wage Theft Ordinance. So overall, we seek to engage communities and protect workers through a strong investigation and enforcement regime. And what we do is we process complaints, we conduct investigations, we can mediate disputes, we can direct settlement proceedings, we do issue violations, and if necessary, we can seek licensure discipline against employers. It's our goal to provide outreach and education to employers and workers. We want employers and workers alike to be fully educated on what the worker protections are so that everybody can be compliant. As you see some stats to the right, for the calendar year of 2023, we received over 600 complaints, over 400 of which we were able to close out. And we put $430,000 back into workers' pockets in restitution. Also, just want to point out that this presentation is intended to offer general guidance on the Fair Workweek Ordinance. We're not providing any legal advice, and that employers should consult their own legal counsel to determine any actions that they should or should not take to comply with the ordinance. Okay, having said that, let's dive right in. What is the intent of the ordinance? What's its purpose? So the purpose is to enact and enforce fair and equitable employment scheduling practices in the city of Chicago, and to provide the working people of Chicago with protections that ensure employer scheduling practices do not unreasonably prevent workers from attending to their families' health, education, and other obligations, and to require employers needing additional hours, whether temporary or permanent, to first offer those to current part-time covered employees. So rather than grabbing temp workers every time you need a shift picked up. This ordinance allows for those hours to be offered to covered employees first. So essentially, it's a predictive scheduling law that ensures hourly workers in Chicago are guaranteed fair working conditions and scheduling stability, because everybody has their own lives. They like to know their own schedule, and this ordinance protects that for them. So who's actually covered? Let's talk about employees first. So to be an employee that's covered under the Fair Workweek Ordinance, you must be an actual employee. So employee working for an employer receiving a W-2, as differentiated from an independent contractor receiving 1099, working as an independent contractor in that capacity. So you must be an employee, or you could be a temp or day labor worker who works 420 hours in any 18-month period. Assuming you meet the rest of the criteria, you could be considered an employee covered under the Fair Workweek Ordinance as well. You must perform most of the work in Chicago. So if I work for a covered industry and I meet all the qualifications, but I primarily work in Skokie and work in Chicago infrequently, I'm not going to be covered as a covered employee. Now, there's only specific industries that are covered by the Fair Workweek Ordinance, and that is building services, healthcare, hotels, manufacturing, restaurants, retail, and warehouse services. Of those, we'll go into greater detail on an upcoming slide. There is a maximum wage in order to qualify under the Fair Workweek Ordinance. So at most, if you're a salaried employee, you're receiving a salary at $61,149.35 per year, or $31.85 per hour. So those earning figures update annually. So if you do or you don't meet that threshold, those figures change every July 1st, and we post them every June in advance of the new rates going into effect. Plus, as an employee, you must work for an employer that's primarily engaged in one of those covered industries, who is employing 100 or more employees, 50 of whom are covered employees by the ordinance. So let's talk about employers. Which employers are covered under the Fair Workweek? So as we stated, they must be engaged in one of these covered industries. Building services, which can mean the care and maintenance of property, including but not limited to janitorial services, building maintenance services, and security services. Hotels, healthcare, manufacturing, meaning the production of tangible goods for use from raw or prepared materials by giving them new forms, qualities, properties, or combinations. So taking some raw materials and manufacturing it into something new. That's part of the definition of manufacturing. Warehouse services, retail, and restaurants. Now, it gets a little tricky when it comes to restaurants. Restaurants have additional requirements in order to fall under the Fair Workweek Ordinance. So they must have 30 global locations and 250 employees globally to start. For the rest of the covered industries under number 2, it states that the global number of global employees between all locations needs to be 100 employees, or 250 for not-for-profits. And 50 of those employees must be covered employees under the Fair Workweek Ordinance. So as we talked about restaurants, there's an additional requirement for the restaurants as far as number of locations, different number of employees, but sole franchises with 3 or fewer locations are not going to be considered employers. Franchises with 4 or more locations might be employers under the Fair Workweek Ordinance. So as defined in the municipal code, employer means a person who meets all of the following: employing globally 100 or more employees, or in the case of not-for-profit corporations, 250 or more employees, 50 of whom are covered employees. And anytime you see covered employees that's capitalized, that's going to be as defined by ordinance, and primarily engaged in a covered industry. The number of covered employees will be aggregated if they're employed by members of a single unitary business group. So single unitary business group. It's going to be a number of persons related through common ownership or control whose business activities are in the same general line. So we tend to see this a lot with restaurants. Let's take, for example, if you are a restaurant group that owns a number of restaurants, you're tied to a restaurant chain that has over 30 locations globally. However, I've broken down my structure into having separate LLCs for each individual restaurant, but I have common ownership or control, and they're under centralized management. If I'm a restaurant group and I have all of those restaurants, those could be qualified under a single unitary business group. In order to determine if you qualify for a single unitary business group or as a unitary business group, we recommend that you seek out your own legal counsel to determine that, or your tax professional. All right, so what rights does the Fair Workweek provide? So first of all, there's an initial estimate. Before or upon beginning employment, an employee should receive an initial estimate of days and hours to be worked. So if I get hired by a company that's falls under the Fair Workweek Ordinance, I need to know what are my projected days and hours that I'm going to work. What's the average number of hours? Am I going to be on call? Am I going to work Monday through Friday? Which work location am I going to be at? That's an initial estimate to give to the employee so they can determine, hey, how do I know which days I'm going to work? Now, if you give a blank piece of paper and say, any of our locations 24/7, that's not going to be acceptable. That doesn't fall under an initial estimate. That does nothing. It also provides protection for schedule changes. So workers must receive their work schedule 14 days ahead of time. If there's any unscheduled hours that are offered less than 14 days in advance, the worker has the right to decline that. So if those weren't previously scheduled and it's within 14 days of the scheduled start date, I as a worker, I as a covered employee, I can decline those hours. Or I could get predictability pay. So predictability pay is going to be offered for any schedule change within 14 days of the posted schedule. So employees are entitled to compensation for changes that an employer makes to the work schedule after the deadline. There's also a protection for canceled hours. Any canceled hours over 24 hours in between the 14-day schedule notice, that's going to fall under predictability pay. But if it's under 24 hours notice and my hours are cut, I'm due 50% pay for any of those hours that were canceled less than 24 hours before the start of a shift. Right to rest. An employee has the right to decline hours that are scheduled within 10 hours of the end of yesterday's shift. So if I'm closing in a restaurant and we go to 11 o'clock at night, and then my manager, Bob, says, hey, thanks for working a great shift. I need you to come back in at 7 to open up. Well, I have the right to decline those hours. If I do decide to work those hours, I qualify for right to rest pay. And that comes in at 1.25 times pay for the shifts that begin within 10 hours of yesterday's shift. Now, that's not just for the hours that fall within 10 hours. It covers the whole shift that I'm scheduled to work the next day, if it falls within that right to rest 10 hours. Oops. So let's talk a little bit more about predictability pay, canceled hours, and right to rest, because those are the topics that can pay out to workers. So a covered employee can decline shifts if offered within 14 days from the start of the schedule. Now, I want to point out that's from the start of the schedule. So let's say it's within 11 days of when the schedule is posted, when the schedule starts. But there's a change in the schedule 15 days out. This qualifies because it's within 14 days of the start of the schedule. So I can decline a shift if that happens. But if a shift change, which we mean by added time, subtraction, or change of hours, if that's offered less than 14 days from the start of the schedule, a worker has the right to accept the shift and get predictability pay. And that's 1 hour at the regular rate of pay. So, okay, I'll work that shift, but you know what? I'm due an hour of predictability pay. And and the employer is required to pay me that. If an employee accepts the shift with a mutual agreement, we both agree that I want to work the shift. I'm aware that predictability is pay is offered, but you know what, it's a mutual agreement. Let's just both agree that I'm going to take this shift. Then that 1 hour of extra pay is waived. So the employee consents to the shift change and waives the extra pay. They can do that. Employees receive 50% of pay if hours are subtracted less than 24 hours prior to a shift. And that also includes hours that are subtracted while you're working a shift. So I came in at 8, I'm supposed to work till 4. And here it is about 2 o'clock, and my manager comes by and says, "Hey, Adam, turns out we don't need you, so you're cut. You're free to go home." Okay, I'll go home. I'll take those 2 hours of my time, but I get paid 50% of my regular rate for those 2 hours that are missing, because I was depending on working a couple extra hours, but unfortunately management had a different idea, but I'm still going to get half my pay for those hours. And that's what the Fair Workweek provides. As we talked about right to rest, employees have the right to decline scheduled hours that are less than 10 hours after the end of the previous day's shift. And when they work a shift that begins less than 10 hours, they get that 1.25 times the regular rate of pay for that shift, the entire shift. So there are some exceptions to Fair Workweek Ordinance, some situations where predictability pay is not going to apply. A lot of these are fairly extreme, and then just a few of them we see that are fairly common. The first one, we've got threats to employers, employees, or property, or when civil authorities recommend that work not begin or continue. So if there's some sort of threat, let's say there's protests or there's a bomb threat to the building, that's out of my control as an employer. I've got to cut the shifts, and it's not safe for people to be here. That's an exception under the Fair Workweek Ordinance. If public utilities fail to supply electricity, water, and gas, or the sewer system fails to serve the location, that's out of my control as an employer. I can't do anything about that. I can't have my employees here without functioning sewage and water, electricity. That's out of my control. That's covered under the exceptions. Acts of nature, which include but are not limited to flood, earthquake, tornado, or blizzard. Now, those are fairly extreme acts of nature. An employer can't look outside and say, "Hey, the clouds are dark. I think it's going to rain. I need to cut shifts." I'm not paying predictability pay for anything. That's not what it calls for. It's covered for extreme acts of nature, such as the ones listed below. War, let's hope not. Civil unrest, strikes, threats to public safety, or pandemics. Those are fairly extreme, but it's not something that we haven't seen before. Now, when it comes to pandemic, that's going to be not just, "Hey, I think we're still in a pandemic. I'm not paying predictability pay to any of my employees." We're talking about when a pandemic comes and actually affects an operating plan due to the extreme nature of the pandemic. So we're however many years in, whether it's even still ongoing, predictability pay still applies at this point. Number 5, now we're getting into some more common situations that fall under the exceptions. So a schedule change that is the result of a mutually agreed upon shift, trade, or coverage arrangement between covered employees, which is also subject to any existing employer policy. That's between covered employees. So as it's capitalized there, that means that it falls under the definition of covered employees. So those that meet all the requirements we talked about earlier, including the wage and salary requirements. So if my coworker Jim wants to trade shifts with me, he's got something else going on, we can agree ourselves mutually to change shifts, present it to management, and they wouldn't be required to provide predictability pay. If that happens between an employee who is not a covered employee by ordinance, this does not fall under the exceptions. Number 6, a schedule change that is mutually agreed to by the covered employee and the employer and is confirmed in writing. This is what we spoke about a little bit earlier, as far as, hey, let's just say I want some more hours. I got a trip coming up. I can take as many hours as I can get. If you've got hours, I'll take them. I agree to it. I don't need predictability pay. Just give me what you got. We can do that, and the employer wouldn't have to pay predictability pay so long as it is confirmed in writing, and I understand that I am waiving my right to receive predictability pay by doing that. Number 7, an employee requests a shift change that is confirmed in writing, including but not limited to the use of sick leave, vacation leave, or other policies offered by the employer. So if I say, hey, you know what, I've got a doctor's appointment tomorrow, I'd like to move my shift to Thursday, employer is not going to be required to provide predictability pay in that situation, even though there's a schedule change. If an employer subtracts hours from a work schedule for disciplinary reasons or just cause, provided that the employer documents the incident, that's not going to be required to pay predictability pay. So let's say you're suspended for performance. Hey, you did something egregious. I'm sending you home. I'm not going to be required to pay predictability pay as long as it is for a just cause. Or let's say there was a physical altercation with employees. I had to separate them. I had to call the police, whatever the case may be. If it's for a disciplinary reason for just cause, that's an exception under the Fair Workweek Ordinance as well. A few more are a banquet event that is scheduled or rescheduled under circumstances that are outside the employer's control, and the attendee count increases by more than 20%, or the banquet event is scheduled within 48 hours of the event occurring after the employer provides a posted work schedule. Another one in manufacturing, if something's outside of the control of the manufacturer, let's say there's supposed to be a delivery of raw materials that we need in order to continue our manufacturing, whether we're a food manufacturing plant and a key ingredient is not going to make it, there's an accident, et cetera. If it's outside of the employer's control, it could fall under this exception. There are a number of exceptions with regard to healthcare employers. So if there's any declared national, state, or municipal disaster or other catastrophic event causing a hospital to activate its emergency operations plan, that could fall under the exception to Fair Workweek. Also, any circumstance in which a patient care needs require specialized skill through the completion of a procedure. Somebody's receiving a procedure, medical procedure, and I'm a covered employee. I'm only scheduled till 8 to 4. It's going to run past 4 hours. I'm not allowed to start negotiating my predictability pay in the middle of the operation. This is covered under one of the exceptions. Or any unexpected substantial increase in demand to healthcare due to large public events, severe weather, violence, or other circumstances beyond the employer's control. So a lot of these exceptions are stated as beyond the employer's control. So it's not their fault that they're not scheduling people well in advance and properly. These are rare situations for the most part that cause disruptions in scheduling. Another one is a ticketed event is canceled, scheduled, rescheduled, postponed, delayed, or increases in expected attendance by 20% or more. This could fall under the exceptions as well. And then also when a covered employee self-schedules. So we've received some questions about self-scheduling in the past and what exactly is it? I don't know what that is. So I'll give an example of if I work in a warehouse and I have an agreement with an employer that I'll work 20 hours a week. It doesn't matter when those hours are. I'll create my own schedule. I'll come in as long as I do the work and I put in the hours. They don't mind when I work. Now, if I change my schedule and I change it multiple times, that's not going to qualify for predictability pay. Otherwise, I'd be changing my schedule all day, every day, raking in those predictability pays hours at a time, but that's an exception. Nice try, not going to happen. All right, so mutual agreements. That's one of the exceptions that we talked about. So what exactly is a mutual agreement? We talked about when covered employees mutually agree to trade shifts. I gave the example that we're both covered employees. This day works better for me. This day works better for my fellow coworker. We agree, we present it to management. It follows the workplace rules. That's a mutual agreement. A covered employee and employer both mutually agree to a change and confirm it in writing, and the employee is aware that they're due predictability pay and waive that right, that's a mutual agreement. Or if a covered employee requests a shift change that is required, that is confirmed in writing about the use of sick leave, vacation leave, or any other policies. So if the employee initiates the request, that could fall under the mutual agreements. Now, what is not a mutual agreement? Well, if I'm a manager and I go around and I tell people that I've got shifts, but I'm only going to offer them if people waive their right to predictability pay, that's not a mutual agreement. You're essentially forcing an employee to waive their rights to something in order to offer them their shift. Or when a manager presses, let's say, radio buttons on a timekeeping system to accept the mutual agreement. So if I offer shifts out to employees and I'm just clicking the button, yes, they agreed, yes, they agreed, that's not a mutual agreement. Using any system that automatically records a worker's willingness to perform a shift change, that's essentially related to the example that I gave. It needs to be in writing and agreed upon with the employee knowing their rights, that they're waiving the right to predictability pay. So let's talk about retaliation. So retaliation for exercising any right under the Fair Workweek Ordinance is also prohibited. Some of the retaliation that this includes would be termination, denial of promotions, negative evaluations, punitive schedule changes, punitive decreases in the desirability of work assignments, or acts of harassment. So just because I'm exercising my rights under the Fair Workweek Ordinance doesn't mean that I should feel threatened by my employer or given worse schedules, worse evaluations. I'm exercising my rights, and there are protections in this ordinance regarding retaliation. And each of these can result in a $1,000 fine per occurrence. So it's fairly hefty. They can add up over time. When it comes to Fair Workweek Ordinance, this is one of the few ordinances that require a public or requires a notice to be posted at the work site. So every employer shall post a notice advising covered employees of their Fair Workweek rights in a conspicuous place in each facility where any covered employee works. And this is the Fair Workweek notice that's current right now. So this is the notice. It's available on our website. It needs to be posted at the job site. At the workplace, the notices need to be no less than 11 by 17, and it needs to be in a workplace area where it can be seen by employees. Additionally, every employer shall provide the notice with the employee's first paycheck and annually on or following July 1st. So we've also received questions about the first paycheck. We do allow that to be part of a training or an onboarding process. You can provide it there or along with how the ordinance states specifically with the first paycheck. But as a reminder, every year that the wage rate increases, which goes into effect on July 1st, that notice needs to be provided to employees as well. As far as the paycheck notice size, that can be 8.5 by 11, and those can also be submitted electronically as well. So these notices need to be in English and any other language spoken by employees that do not speak English. But that is provided that we have created that notice on our OLS website. So that could qualify under 9 different languages we now have for the notice postings. So I included a few frequently asked questions that we received specifically about how predictability pay is calculated. These are taken directly from our frequently asked questions document, which is available on our website in both English and Spanish. So the first one asks about a covered employee Are they defined by their base salary, hourly wage, or does the salary include overtime, bonuses, and other types of pay? Well, for the purpose of the Fair Workweek Ordinance, salary or hourly wage will always be calculated using the base rate of pay and will not consider overtime, tips, benefits, bonuses, or any other form of pay beyond the base rate. There's one exception for hotel workers with set service fees, but in all other situations, it's the base rate of pay excluding bonuses, overtime, and tips. So if I have a tipped employee who's due predictability pay, they're making the sub minimum wage, what do I owe them? We get this question frequently. Well, if the covered employee is a tipped employee, predictability pay is calculated based on the base rate of pay before tips or the minimum wage, whichever is higher. So if they're a tipped employee receiving the sub minimum wage, that predictability pay hour is going to be at the minimum wage rate. If they're a tipped employee and they make the minimum wage or above, that's going to be their base rate of pay. And then how is predictability pay calculated for salaried employees? Well, we do predictability pay on an hourly basis. So essentially the answer to this question is a calculation. So we take the regular rate of pay for a salaried employee, we'll divide it by 52 weeks, and then multiply it by the number of, and then we'll calculate it by the number of hours that they work in a week. So assuming a full-time schedule, that would be by 40 hours. So it's going to be on an hourly basis for salaried employees. So here we are at the OLS website, which is a valuable resource tool for employees and employers alike. Included a few screenshots to show you just the main layout of various sections of the landing page. So each ordinance under the OLS jurisdiction has its own section or click box where you can click on that specific labor law and it will take you to a landing page for that specific ordinance section, which includes links to the ordinance, the frequently asked document links, fact sheets, general information regarding that specific ordinance. There's also a public notice section on our page, so that's going to link you to the 2 public notices that are required. So we have the minimum wage, sick paid leave, paid sick leave, and paid leave notice, and we also have the Fair Workweek notice that's required if applicable. We also have our Chicago labor law educational resources, which provides model policies, fact sheets, additional resources, and most of the resources that we have on our website are now available in 9 languages. Those 9 languages are English, Spanish, Polish, Korean, Mandarin, Tagalog, Thai, Vietnamese, and Ukrainian. And we're currently working on providing 3 additional languages as well. Continuing on with the OLS website, the Fair Workweek page, since that's the topic of today's discussion, also has a quick overview of the ordinance, along with a direct link to the ordinance. There's a link to download the public notice that's required. And again, our frequently asked question document, which is available in English and Spanish with 34 answered questions, plus example situations of mutual agreements. And that document was updated just 2 months ago. So this webinar, along with the other webinars that we host publicly, can be found on our BACP YouTube page. We have over 50 webinars specific to OLS that we have hosted throughout the years that you can peruse through, view at your leisure. They're available to watch whenever it's convenient for you. And many of the webinars are available in Spanish along with their English version. And this link is also available from the OLS website directly. And as far as our contact information, if you ever need to reach out to us, if you have questions about whether you're protected by an ordinance or if you're an employer seeking additional information, Our main line is 312-744-2211. Or you can email us, bacplaborstandards@cityofchicago.org. If you have any specific questions related to your situation or any legal questions that you're concerned about, email is a preferred method so that we can grab all of the details clearly and provide you with a proper response. Our mailing address is 2350 West Ogden Avenue. We're on the second floor, and that is in Chicago, Illinois, 60608.
Looks like we have a few questions. What if you offer an open shift to all employees and an employee voluntarily picks up the shift? Is pay owed?
Okay, so for that question, it essentially is teetering the line. So if you're providing any open schedule out to any individual, you're just putting it out there that it's available, and that's essentially it. If you're putting it out there and mandating that shift to be covered by somebody, anybody it needs to be, then it could potentially fall under predictability pay. But just posting available hours in general out to everybody doesn't necessarily fall under predictability pay. You're just providing that information out to your employees. And at that point, if they want to come forward and grab those shifts, they're free to do that. Oh, I see a question from somebody about including the ordinance in their onboarding folder during orientation. Yes, you can do that. It does not necessarily need to be included with their first paycheck. I believe we have that question in our frequently asked questions. But yeah, it can be part of the onboarding process. But just as a reminder, every July 1st, on or after that paycheck, they're going to need to be provided with the updated notice.
If the shift is available to all employees, it's voluntarily picked up by the employee, then predictability pay will not be owed.
Yeah, I think that's essentially similar to the first question.
Can in writing via text or email or via an electronic scheduling tool, can we offer a day off to schedule employees and waive predictability pay?
Is that in the chat? I'd like to read that.
Yes. Came in at 10:22.
Okay, it looks like there were two questions there. So in writing can be through an electronic scheduling tool. I'd like to learn more about that second question scenario. So I'll probably request that email be sent by email to our inbox and provide a little bit more information about that situation. And also, if people weren't aware, there's going to be a Spanish version of this webinar today at 2 o'clock as well.
I don't see any new questions. I can give you like 2 more minutes to put in your questions before we end today's webinar.
So there's an additional question about picking up shifts voluntarily. And at that point, if you're mutually agreeing with the employer that you want to pick up that shift and waive your predictability pay, that's perfectly fine.
Okay, it looks like we don't have any more questions. If you are part of the BACP Entrepreneur Certificate Program, you will automatically receive credit for joining today's webinar. To view this webinar and past webinars, please visit our YouTube page at youtube.com/Chicago BACP. To learn more about our upcoming webinars and register for them, please visit chicago.gov/BACP webinars. Thank you to our presenters for today and have a great day.